Hey guys, Mario here, former Amazon seller and now IP and e-commerce attorney. And just want to talk to you guys about three things that every Amazon seller needs to know about trademarks and private label. I used to do private label. I started about 5, 6 years ago, maybe closer to 7. I started in law school, and I built and sold two seven-figure Amazon PL brands. I sold one of them on Empire Flippers. It was in the kitchen slash outdoor garden niche, and the other one, the other PL brand, was in electronics. So a lot of people ask me, why did you sell it if you were doing so well? Uh, on the first one, the home and kitchen brand, we got an offer, and hate to say, it, but we really couldn't refuse it. And at the time, I was getting married and just needed a lot of cash, so decided to sell that one. And the second one, I guess I just got hungry for more cash, so just sold the second one too. But a little bit about our law firm. So what we do that's different than other law firms is, number one, we're very familiar with Amazon because we've sold on Amazon, and most of the people working with us have sold on Amazon. So we understand the law and Amazon, and that's why we kind of tell people that we take a 360-degree approach on your Amazon issues. So if you come to us with anything with trademarks, copyrights, patents, or trade secrets, um, probably about 90% of the time, we could give you some pointers about how to kind of optimize your listings or just overall help out with your Amazon business. Other things that we do are ACE and account reinstatements, and also if there's any issues such as issues with review manipulation or bogus IP complaints, we will go after and file suits against the party that's filing the bogus complaints. So we'll go after them for unfair competition or unfair business practices and all of that. So now let's get into the meat of it. So we've been getting a lot of questions that are very similar to what I've got here. So the first question is, can you apply to use the same brand name in multiple categories for extra filing fees? So what you're talking about here is if you've got a brand, sorry, a private label brand, and you're trying to register for a trademark, they're wondering if they could file a trademark or use the same brand name to file trademarks in different categories. Um, for example, if you want to sell pet supplies, home and garden stuff, and wedding stuff, and electronics, they're asking if you need a separate brand for each one of those niches or categories, or can you just have one brand name and then you would be able to trademark that brand name and kind of have it be an umbrella brand name for each one of those categories? And the answer is yes. You guys could definitely do that, and I'll go into more detail in the next thing, in the next slide. Again, the second question is, or is it better to create three separate brands, logos, and websites and apply for a trademark for each one of those separate brand names or marks? And the third thing I want to talk to you guys about is Trademark Spectrum. So for those of you just starting out, what kind of trademark or what kind of brand name should you be looking for, or what should you call your brand so you have a better chance of getting a trademark? So those are the three things I want to talk to you guys about. So going to the first question, can you apply to use the same brand name in multiple categories for filing trademarks? So the answer is yes. You could look at other companies who do this, such as General Electrics, where they sell anything from air conditioning to home appliances to and pretty much anything else you can think of, such as other industrial mechanical parts and all that. So you can have a brand name, kind of like an umbrella um, brand that you trademark and then keep on adding different categories under the international class for the USPTO. So you can do that. When can you do that? So if you've already started out selling on Amazon, and let's say you go into three different products, let's say you do doormats and you do iPhone cases, and you also decide that you want to get into wedding cards. So if you've got all three, then you could apply to have your trademark for all three of those categories. We call it categories, but the USPTO calls it international classes. Doesn't matter what you use. They're both. You could use it to interchangeably. So you could either do it up front if you're already selling it, or if you start selling home and kitchen stuff and then later on you're going into electronics, you could go back to the USPTO and let them know that, hey, I've already got a trademark for home and kitchen stuff, but now I want to add this other category, and they'll do that. You will have to file a new application, but they could definitely do that. Something else is if you do want to kind of break it up into three separate brands, I would say that's more of a business decision. So the way I kind of did it is I broke it up into two different brands. My home and kitchen and slash garden stuff and outdoor stuff was under one brand, and then the electronic stuff was under the second brand. The reason I like doing that is because when you do sell, if that's your goal, then you could kind of sell it as two separate brands and businesses. Now, obviously, you've only got one Amazon account. So if you've only got one Amazon account and got two brands under there, you can separate it. Amazon's pretty good about kind of letting you have an additional Amazon seller account as long as you ask for permission and let them know that you're not going to be selling the same items on both your accounts, and that you'll have separate legal entities, separate mailing addresses, and separate credit cards. They're okay with that. So that's one option as far as separating it. The other one is just having everything under one account. So that's really a business decision. If you do decide to have everything under the same brand, then what you guys could do on your Shopify websites when you guys get to that point is kind of just create a website for your brand called, for example, let's say it's brandname.com, and then you guys could separate it into categories on your website. For example, backslash home and garden, brandname.com backslash electronics, and so forth. So that's kind of helpful when you do that. But if you guys don't have a trademark yet, haven't registered, or don't have a brand name yet, what I want to do is kind of look at the trademark spectrum and kind of explain why one brand name would be better than the other in the eyes of the USPTO. So what I'm going to do is pull this up. So this is called the trademark spectrum. Kind of identifies the strength of your trademark and how likely it is to get approved. Some of these that we'll go over, you'll see that you can't even register it for a brand name or as a trademark. So for example, the worst kind of brand name you could have is called a generic. So this is a common product or service name. For example, having knife for a chef's knife. So knife being your brand name, that's a horrible idea because you're not going to be able to trademark that. And the purpose of that is the USPTO and the government won't let you trademark knife for a chef's knife or for like a home and kitchen brand, because they want to allow other sellers to use that. So generic brand names or marks are also not protectable. You can't even register it with the USPTO, so stay away from things like that. The second stage of as far as the trademark spectrum would be descriptive things. These are marks that describe your products or a characteristic of your product. For example, if you're selling a battery, whether it's a cell phone battery or a home battery, computer battery, doesn't matter. If you've got a brand name that's long-lasting battery, the USPTO is only going to be able to register it or even let you apply for it if you've shown that you've acquired distinctiveness. This is something that's very difficult to do. There's case on it, a common law case on it, about a company that spent about $25 million on advertising their cereal, and they still weren't able to kind of acquire that distinctiveness and be considered a descriptive mark so they could register with the USPTO and acquire and get protection. So stay away from descriptive marks or brand names. Kind of in the middle of it are suggestive marks, and this is something that suggests an attribute. So it's different than descriptive because this only suggests, and here's what I mean. So if you've if you're selling a garlic peeler, so sorry, I had to laugh at that. I created this a while ago and just saw garlic peeler, everyone's favorite PL item, right? So if you're selling a garlic peeler and you want to name your brand No Tears, that would be considered suggestive. It's different than descriptive because if you just look at No Tears, you really wouldn't know what the brand is for. You wouldn't know that it's garlic peeler. So if you've got something like that, that would be considered suggestive. Again, these are marks that um, suggest an attribute of a product without actually describing it. A little bit of imagination is required for you to kind of figure out what the product is when you look at the brand name or the mark. Another example of a suggestive mark is if you've got PPC software, such for example for PPC optimization, and you name it ACOS Bully, that would be considered suggestive because doesn't really right away describe it, but it's more suggestive. It takes a little bit of imagination for you to kind of understand and realize that it's PPC software. Suggestive marks are generally protectable and registrable, although they're weak in the eyes of the USPTO. So moving on to the other end of the spectrum, where these are marks that you want to have, or brand names that you kind of want to have fit into these categories. One of them is arbitrary. So these are marks that have a real word, but one that is used in a way that is not connected to its common meaning or that common product. For example, Tesla for automobiles or Apple for phones. Apple is a real word. Tesla is a new word. Is a real word, but they're not connected to its common meaning. So Apple for phones and all that, those would be considered arbitrary. Again, these are always protectable and registrable. So this was something that would be considered, if you've got a brand name that fits that category, arbitrary category, then that would be considered a strong mark. But now moving on to the strongest mark, a very strong mark, that would be the category of fanciful. So this is a made up word or phrase. For example, Cisco for networking equipment and all of that. Cisco is a made-up word. If you guys don't know, they started out as San Francisco, so they just took Cisco, the last 3 or 6 letters of San Francisco, and kind of made that their brand name. Or our law firm Esco, that's really a made-up word. What we did is we grabbed ESQ, which is short for Esquire, which, if you don't know, means attorney or lawyer, and kind of added go to it and kind of made up a word. So these are considered the strongest marks, and if you could get your brand name to fall into either the fanciful category or arbitrary category, you'll have a lot better luck getting a trademark registration. So again, just to review, we want to stay away from generic, descriptive, and suggestive, and go more towards arbitrary and fanciful. Going back to our presentation. So that's what we've got, the 3 questions that most people ask. And hopefully this video did help you guys out. If you guys have any questions or comments or want us to cover any other categories, please go ahead and email us at info@esco.com, or if you need to get a hold of us, if you need help with anything to do with Amazon and the law, you could give us a call, shoot us an email, or go to our website. Hope this was helpful, and please keep in mind these tips that we provide, they're not meant to be legal advice. If every case is very different and very fact specific, so if you've got specific questions about your Amazon business and the law, please reach out to an attorney. Again, we're always here to help, so any questions, please let us know.